quite a few people that have already jumped on here, so I'm going to go ahead and do the introduction of Convirza, and then we're going to get started with the presentation, so we make sure we give Rachel enough time. So welcome to any new people that are joining the Convirza kind of webinar series for the first time. We try to hold these weekly webinars on different topics around call marketing, essentially. Convirza, for those that don't know kind of who we are and what we do. Convirza, we're a software company that specializes in working with advertisers that want to track phone calls back to advertising campaigns. And we have a pretty cool technology that allows us to record those phone calls that are coming from your advertising campaigns and analyze the conversation that's on the phone. So we're able to use language learning software to understand the conversation and give you data back as to what happened on the phone call. So we're kind of in the call marketing space, and so by default we typically have webinars where we discuss different marketing topics and other topics around phone calls and call marketing, those type of things. So we're really excited today to have Rachel on to talk to us about compliance and call recordings, because it's a common question we get every day is, okay, if I'm going to record these calls, how do I make sure that I'm compliant in doing that? And so we're really excited to have her expertise on today to discuss that. Again, it looks like we've got about another 20 or 30 people that have just joined us recently. How the process is going to work, I'm going to hand over the presentation to Rachel here shortly. And during the presentation, if you want to ask questions, we encourage as many questions as we can get. So there's a little question box on the little control panel you have on your GoToWebinar. Please ask questions there. And if there's a lot of questions on a slide or something like that, we'll stop and ask that question. But the majority of the questions we'll ask at the end of the presentation, so we can answer all those for you. But we'd like to encourage as much interaction as we can. So please ask questions, and so we can make sure that we're being clear on kind of the on the presentation. After the presentation's over, like I said at the beginning, we have recorded the presentation, so we'll post that on our website. And then if you want, we'll also have some of our reps follow up with you if you have additional questions or interest in something. They can set up a time to go through a call with you and walk you through, answer any of your other additional questions. So kind of with that being said, I'm going to bring Rachel on now, and I'm going to kind of turn the time over to her, and she can begin the presentation. So Rachel, go ahead. You've got the floor, and we look forward to hearing your presentation.
Thanks so much, Brett, and thanks everyone for attending today's webinar. As Brett said, my name is Rachel Hirsch, and I'm an attorney at the Washington, D.C.-based law firm of IFRA PLLC. I focus a large part of my practice counseling and defending marketers, call centers, and their solution providers in both everyday compliance issues and in investigations and litigation instituted by state and federal agencies and private plaintiffs. So I've known the folks from Convirza for a long time, and I've always wanted to team up with them to do a webinar. And when we were discussing topics for a webinar, as Brett said, I learned that there is a PCI redaction tool that Convirza has, which Brett will tell you a little bit more about at the end of this webinar, and which can be used by marketers and their call centers to better protect sensitive financial data that is collected from consumers. And this led to today's topic, the road to compliant call recordings. PCI compliance is one aspect of compliant call recordings, But what are the other issues that call centers and marketers should be aware of when it comes to calling their customers? In today's webinar, we're going to explore a few topics. One being the need for PCI compliance by call centers in the age of data breaches. The second being the importance of collecting, recording, and storing customer data under the Telephone Consumer Protection Act. The third is the disclosure requirements that telemarketers need to make under the TSR, which we'll talk about. And throughout, interspersed throughout, we're going to talk about best practices for call centers and telemarketers in recording calls. Oh, Brett, I'm just trying to do the screen. I don't know if I can.
What's that?
Oh, there we go. Just working on the screen. So there are many reasons that a company would record a call. For some, it's not a matter of choice. Industry regulations mandate that they record some or all of their consumer transactions. For others, call recordings is a vital part of coaching and training programs. One reason for call recordings is for dispute resolution. Many companies providing sales and service support via the telephone can benefit by using recorded calls to resolve disputes. For instance, as we will discuss later, when a company faces a billing dispute from a consumer, a recorded call can be crucial to resolving that dispute and demonstrating that the consumer affirmatively and unambiguously consented to clear billing disclosures. Another reason for a call recording would be agent training. So it's the most well-known recording of all time, heard by thousands daily, and that is, this call may be monitored or recorded for quality and training purposes. Using pre-recorded calls in the training room is often preferred to live monitoring. So with recorded calls, you are able to ensure that the content of the call is appropriate and adheres to the training curriculum. By doing this type of observation in the training room and not on the live call floor, you are able to provide a more consistent learning experience. And as we all know, because all agents are learning from the same calls and the same agents, and the same calls and the same review, you would eliminate randomization and wildcards, which are inherent in live monitoring. So for that reason, call recordings could be very important. The third reason is what we discussed earlier, which is industry regulation. Many industries have federal and other regulations that make recording a necessity. Financial institutions, for example, need records of all customer transactions, including telephone calls. Retailers, telecommunication companies, catalog houses, and e-commerce businesses also need to record sales verifications. So there are many reasons that call recordings are important, and we're going to discuss the laws that affect call recordings. So each state has its own laws regarding the recording of telephone calls. The key differentiator in these laws is the number of parties to the call that must provide informed consent to the recording. In most states, what we have is called one-party consent. So if you, as the person making the call, consent to being recorded, the person receiving the call or the person you are calling does not need to consent. It almost doesn't make sense because, of course, if you're the one recording it and you're thinking you're going to record it, you obviously do consent to a call. In those states, it basically means if you decide you're going to record a call, it doesn't matter what the other person thinks. However, in the remaining 12 states, all parties must consent, meaning the person placing the call and the person receiving the call. These are called usually two-party consent states, but the term is somewhat of a misnomer because all parties on the call, and there may be more than two, need to consent. So those states are listed for you here, and they're California, which you would expect given their strict call recording laws, Connecticut, Florida, Illinois, Maryland, Massachusetts, Michigan, Montana, Nevada, New Hampshire, Pennsylvania, and Washington State. The question often arises, what happens when a person in a one-party state calls a person in a two-party state? For example, let's say a call center agent in Ohio, which is a one-party state, calls a person in neighboring Pennsylvania, which is a two-party state. If the recording takes place in Ohio, is it under Ohio's laws and jurisdiction, or do Pennsylvania's laws apply? So generally speaking, when you're talking about intrastate laws, which are calls within a single state, those laws would fall under the jurisdiction of that state. So calls made in Ohio to an Ohio resident is considered an intrastate call. All other calls, which are interstate calls, which are state-to-state calls, are subject to federal law. However, most federal laws do not supersede state law if the state law is more restrictive. So rather than engage in a kind of rock, paper, scissors approach as to which state law would apply if you're dealing with a one-party, two-party state situation, the best approach would be to defer to the more restrictive state laws and capture consent from the caller. So to obtain consent to record a call, it is imperative to make a disclosure immediately at the outset of the call. And a typical disclosure is, this call is being recorded and or monitored, the one that we talked about earlier. This disclosure needs to be immediate, and it often may be accompanied by the option of a non-recorded call line, which is available via key press. So you may say this call is being recorded and monitored. To proceed on a non-recorded line, press 2. The most important thing to remember about these disclosures is that timing is key. You can't wait 2 minutes into a call to make a disclosure about the recording. It has to be prompt, immediate, right away, so before you get into your sales pitch, before you talk substance of your call. In the last couple of years, there have been many companies such as Capital One, Bass Pro Shop, and a Cosmopolitan Hotel that have faced class actions alleging violation of California's recording laws, which require the timely and adequate disclosure of the recording and communications with members of the public. These laws form part of California's Invasion of Privacy Act, which makes it illegal to eavesdrop or monitor or record a confidential communication without the consent of all parties. And the way the confidential communications is defined under the law is it includes any communication carried on in circumstances as may be reasonable that indicate that any party to the communication desires it to be confined to the parties thereto. So what does all that legalese mean? That if you're expecting the communication to be private, it better be held confidential. The law, however, explicitly excludes communications in circumstances in which parties to the communication may reasonably expect that the communication may be overheard or recorded. So where there's not an expectation of privacy on the call, those calls are exempted from the law. Wells Fargo is an example of a company that got sued recently under the California law. They settled with the California AG's office who brought the lawsuit. And as part of their settlement, they paid $8.5 million and agreed to certain compliance requirements, such as making a clear and conspicuous and accurate disclosure to any consumer in California of the fact that Wells Fargo was recording the calls. The settlement required that the disclosure occur immediately at the beginning of the call, but it also allowed Wells Fargo to precede this disclosure with an introductory greeting that identified the customer service representative and the entity on behalf of the call that is being made. So for example, the example we have on the bottom is, this is Rachel calling on behalf of Wells Fargo. This call is being recorded and monitored. So this has all the elements that the settlement required. The representative's name, the company on behalf of whom the call is being made, and this call may not be made internally by Wells Fargo. It could be outsourced to a third party who's making the call on their behalf. So as long as you're identifying who the so-called seller is and who the telemarketer is in this call, this was compliant under their settlement agreement. So this is one instance in where the first thing you say does not need to be the call is being recorded and are monitored. You do have an opportunity to introduce yourself, but then you immediately need to get into the disclosure requirements. So what are some best practices to keep in mind when it comes to announcing yourself on a recorded call? Well, it's important to remember that the announcement requirements applies to inbound and outbound calls, including requested return calls. So anytime you're recording a call, you need to make the announcement. So make sure you inform all parties, whether they have called in or your company has called them, that the calls are recorded and or monitored. Also, it's important to remember that recording announcements apply to all types of calls, not just sales and telemarketing calls. It could be an informational call. It could be a charitable call. Anytime you're calling someone and recording them, you need to announce that disclosure. It's very important to maintain proof of an announcement, especially if litigation arises. It's important to keep these call recordings. And this is why call recordings are so important, because you want to be able to say, hey, I told them that I'm recording the call. Their claim is bogus. They have no defense. They have no proof that we didn't do it. And here is the proof that we did disclose. Again, considering offering a non-monitored line. If someone opts for the non-monitored line, make sure you honor that objection. This offer should be made every time a call is made, placed, or received. And if no such line is offered and the consumer objects, do not continue the call with the objecting party. So it's really important to listen to what they're saying. If they're saying, no, I don't want to be recorded, you can't keep moving forward if all you have is a recorded line. And then always make sure to implement a short written policy that your customer service agents can remember and that can be carried through and shared with others upon request. And this brings us to the next few practices, which are training your customer service representatives to understand call recording policies. And this is not just a one-time training that happens when you hire your customer service agents. The training should be continuous and done periodically to ensure that everyone is following the rules. Also, make sure the customer service rep can explain the call recording policy if they're asked by a consumer. A consistent organization-wide message that accurately states standard procedure helps ameliorate consumer concerns, and in the event of litigation can bolster a defense. You also want to periodically test call recording procedures, review call recordings, monitor the call room floor, and promptly take corrective action if you see that policies are not being adhered to. The last thing is have your customer service representative sign an acknowledgement that they understand they are being monitored and are recorded. Remember, at least one party needs to consent, and making the customer service representative sign this form holds them accountable and also gives their consent to being on the call. Being in a one-party state, that's important. You at least have to have your customer service rep consent to being recorded on the call. Sometimes customer service training is not enough. There's always going to be instances of an agent going rogue, as I call it, or simply forgetting what to do. For any situations where your agents are providing the notification, you should have a checks and balances system in place to ensure that your staff is adhering to the requirements. So consider the following: employing automated scripts. Even your best agent may be prone to forgetfulness. If your technology permits, you can create automated scripting flows or reminders in a CRM application. Having reminders or guided scripts will help minimize human error. If agents are trained to follow the scripted flow, less repetition is needed in hearing the correct verbiage for the actual scripts. Another tip to employ is quality monitoring. If script adherence is a critical part of job performance, it should be a critical part of an evaluation form for a specific customer service rep. By including this metric on your evaluation forms, you can identify trends in agent or team adherence. This provides valuable insight in regard to who is and who isn't following the required scripting. And then again, speech analytics, which Brett touched upon before. Speech analytics is a technology that will analyze recorded calls and spot keywords and phrases. One key to maximizing effectiveness of speech analytics applications is to control the consistency in how the script is read. So thus, you want to eliminate variations from the script because that's crucial in employing this technology. For example, you don't want one agent to say something to the effect of, is it okay if I record this call? While another one of your agents is saying something to the effect of, I would like to record this call now. Is that all right? You want to keep it consistent. So everyone should be making the same disclosure. So while speech analytics technology is not 100% accurate, it can be effective in identifying trends in agent and team performance. So now that we've talked about recording calls, let's talk about the rules and regulations that are implicated when there are call recordings. One is the Telemarketing Sales Rule. The Telemarketing Sales Rule was issued in 1995, and the rule gives effect to the Telemarketing and Consumer Fraud and Abuse Prevention Act. It's been amended several times by the FTC over the years, and it has a few purposes. One, it gives the FTC and the state AGs law enforcement tools to combat telemarketing fraud. Two, it gives consumers added privacy protections and defenses against unscrupulous telemarketers. And three, it helps consumers tell the difference between fraudulent and legitimate telemarketing. And these are purposes that the FTC has iterated in its own policies for why they give effect to the TSR. So there are certain, the TSR has certain key provisions that are relevant to marketers and call centers. A few of these we're going to talk about in a little bit more detail, but the list is included here. One is it requires disclosure of material information. Second is it prohibits misrepresentations. Third, it limits when telemarketers may call consumers, what business hours are appropriate. It also requires the transmission of caller ID information. It prohibits abandoned outbound calls subject to a safe harbor. It prohibits unauthorized billing. It applies to upsells, even in unsolicited calls from a consumer. So anytime you're trying to sell them on something other than what the original product or service was, it will apply. It sets payment restrictions for sale of certain goods and services, and it requires specific business records to be kept for 2 years. So who must comply with the TSR? The TSR regulates telemarketing, which it defines under the rule as a plan, program, or campaign to induce the purchase of goods or services or a charitable contribution involving more than one interstate telephone call. With some important exceptions, any businesses or individuals that take part in telemarketing must comply with the TSR. This is true whether as telemarketers they initiate or receive phone calls to or from consumers, or whether as sellers they provide, offer to provide, arrange to provide goods or services to consumers in exchange for payment. It makes no difference whether the company makes or receives calls or whether the calls are made from outside the U.S. So long as they are made to consumers in the U.S., the TSR applies. So if you're, for instance, a Canadian company making a call into the U.S., you are subject to the TSR's restrictions and prohibitions. Some types of businesses and individuals, however, are exempted from the TSR because they are outside of the FTC's jurisdiction. Note, however, that while they may be outside the FTC's jurisdiction, they still may be subject to the FCC's jurisdiction. These exceptions are banks, federal credit unions, and federal savings and loans, common carriers like long-distance cell phone carriers and airlines when they're engaged in common carrier activity, and finally, nonprofit organizations. Nevertheless, any individual or company that contracts with one of these three types of entities to provide telemarketing services must comply with the TSR. So the examples that are given by the FTC is, for example, a non-bank company that contracts with the bank to provide telemarketing services on the bank's behalf is covered by the TSR. A non-airline company that contracts with an airline to provide telemarketing services on behalf of the airline is covered. A company that is acting for profit is covered by the TSR if it solicits charitable contributions on behalf of a nonprofit organization. So anytime one of these three exceptions employs or works with outside vendors, outside call centers, those outside vendors and call centers are going to be subject to the TSR, even if the bank or the airline or the nonprofit itself is not subject to the FTC's jurisdiction. We also have some types of calls which are not covered by the rule, regardless of whether the entity making or receiving the call is covered. So those include unsolicited calls from consumers. If you get a call that was an inbound call, not with respect to any advertising or promotions you may have put out there to elicit that inbound call, that would not be covered. Calls placed, like for instance, calls placed by consumers in response to a catalog would also not be covered. B2B calls, unless they involve retail sales of non-durable office or cleaning supplies, or solicit sales or charitable contributions from employees. Those are not covered. Calls made in response to general media advertising, with some important exceptions, are also not covered. Calls made in response to direct mail advertising, also with exceptions, are not covered. So whether the TSR requires these sellers and telemarketers, whether making outbound calls to consumers or receiving inbound calls from consumers, to provide certain material information before the consumer pays for the goods or services that are subject of the sales offer. Material information is defined as information that would likely affect a person's choice of goods or services, or the person's decision to make a charitable contribution. More simply, it is information a consumer needs to make an informed decision about whether or not to buy goods or services. So these are disclosures that need to be made orally or in writing, but that need to be clearly and conspicuously articulated in a manner such that before the consumer pays for the goods or services, he or she can make an informed decision of whether he or she wants to make that purchase. The key thing here is if you fail to make these disclosures, it's considered a deceptive telemarketing act or practice that violates the TSR, and it would subject the seller or the telemarketer to a civil penalty of $40,653 for each violation. So the types of material information that you would need to disclose include the cost and quantity of the product. How much is the consumer going to be paying, and how much will they be receiving for that payment? So for instance, if you are offering what we call a free trial period, what is the cost of the underlying product, even though it's free for that period? And how much of that product is the consumer going to get? Are there material restrictions, limitations, or conditions to the purchase? Those are important disclosures that need to be made as well. If you have a no refund policy, that's going to be important and needs to be disclosed to the consumer, because they have to make that decision whether they want to buy that product and keep it forever and lose out on their money if they don't like it. Price promotion and instances of disclosures are connected with that. Whether you're offering credit card loss protection. A big one is negative option features. Negative option is a term that's used when somebody opts into, let's say, a trial period, and for signing up for that period, once that period expires, they're enrolled in the program, and the only time that the program is canceled if they affirmatively call and cancel. Otherwise, it's passive. It's negative option, meaning they don't have to do anything to be enrolled in the program. What they have to do, the affirmative part of it, is calling to cancel. And then there are also debt relief services disclosures, which I won't get into in detail, that are part of the TSR and are considered material information that needs to be disclosed. So when a telemarketer initiates a call to a consumer, the TSR requires that the telemarketer making an outbound call promptly disclose before any sales pitch is given the following 4 items of information, truthfully, clearly, and conspicuously. The first is the identity of the seller. The seller is the entity that provides the goods or services to the consumer in exchange for payment. The identity of the telemarketer, or the person making the call, need not be disclosed if it is different from the identity of the seller. So if the seller commonly uses, let's say, a fictitious name, a DBA that's registered with appropriate state authorities, it is fine to use that name instead of the seller's legal name. So if you have a DBA that's associated with your company, the person who is making the call on your behalf would just say, this is Rachel calling on behalf of whatever that DBA is. You don't otherwise have to disclose the telemarketing company if that's outsourced. It just needs to be the name of the seller. The other disclosure that needs to be made is the purpose of the call is to sell goods or services. The TSR requires that the purpose of the call be disclosed truthfully and promptly to consumers. How you describe or explain the purpose of the call is up to you, as long as your description is not likely to mislead consumers. For example, it would be untruthful to state that a call is a courtesy call if it's actually a sales call. You also need to disclose the nature of the goods or services being offered. This is just a brief description of the items you are offering for sale. Hi, I'm selling skin cream. Hi, I'm selling debt relief services. Hi, I'm selling nutritional products. In the case of prize promotion, where no purchase or payment is necessary to participate and win, you need to also disclose that, or that a payment, or if a payment or purchase is it does not increase the chances of winning. So if a consumer asks, you must disclose without delay instructions on how to enter the prize promotion without paying any money or purchasing any goods or services. These same disclosures must be made in an upselling transaction if any of the information in these disclosures is different from the initial disclosures that were made. So if the initial transaction was an outbound call subject to the TSR, and then you upsell a product, you would have to make these disclosures. Or if no disclosures were required in the initial transaction, like in a non-sales customer service call, if a product is being offered during that call or something's being offered for sale, you would have to make disclosures in the duration of that call. Call recordings are important to capture these types of disclosures, but they are also very important when disclosures relate to billing practices. The TSR requires that in any telemarketing transaction, sellers and telemarketers obtain the express informed consent of the customer to be charged a specific amount on a particular identified account to pay for the goods or services offered. So what is express informed consent? Under the TSR, consent is expressed if it is affirmatively and unambiguously articulated by the consumer. So what is not affirmative consent? Silence is not express consent. If someone does not say, yes, I agree, go ahead, whatever that is clearly articulates that they want to proceed with the billing, then anything other than that is not going to be considered express consent. Nor is an ambivalent response like, well, maybe, gee, I don't know, or anything that's non-committal, like, You need yes, no. Those are the terms that are going to show whether or not a customer agreed or did not agree to being charged for a specific good or product. And so for consent to be informed, a consumer, prior to giving consent, must receive all the disclosures that are required by the TSR that we just talked about. So for example, consent would not meet the requirement that it be informed if the consumer does not receive all the TSR's required material disclosures, which are both the prompt oral disclosures for outbound calls and the disclosures of all material information required in all telemarketing transactions. So sometimes we have payment methods other than credit and debit cards. Because payment methods other than credit or debit cards lack built-in protection against unauthorized charges and dispute resolution rights, sellers and telemarketers must meet a higher standard for proving authorization. So in lieu of getting written authorization, sellers may utilize audio recording of the consumer giving expressed oral authorization. The audio recording must demonstrate that the consumer received and understands the following pieces of information. That is the number of debits, charges, or payments. There's going to be more than one. The dates, debits, charges, or payments will be submitted for payment. The amount of the debits, charges, or payments. The customer's name. The customer's billing information, which needs to be specific enough that the customer understands which accounts will be used to collect payments. You also need to capture the telephone number that is answered during normal business hours by someone who can answer the consumer's questions. So you have to stay on the phone. If you have questions about your payments, about your billing, please call during the hours of 8 a.m. to 9 p.m. on this telephone number, and an agent will be available to take your questions. And then finally, you also have to disclose the date of the consumer's oral authorization. So if we agreed on March 29, 2017 to debit one of your accounts, then you need to capture that date. The rule also requires that audio recorded oral authorization be made available upon request to a consumer or a consumer's bank or other billing entity. And that's why call recordings, which is the theme of this webinar, are so important. They are proof that you did everything correctly. And if when you don't do everything correctly, they are proof for the customer that you did not make the appropriate disclosures that are required under the rules and regulations. Then we have consent when it comes into play with pre-acquired account information. Pre-acquired account information is any information that enables sellers and telemarketers to place a charge against a consumer's account without getting the account information directly from the consumer during the transaction for which the account will be charged. The use of pre-acquired account information radically changes the usual dynamic in sales transactions, which requires that a telemarketer obtain the customer's acceptance of the offer as well as a customer's account number to be charged. So telemarketers who use pre-acquired account information are able to charge a consumer's account without getting the account number from the consumer during the transaction. Meaning if there are multiple transactions, let's say you get the account number for the initial transaction, and every time thereafter there is going to be a charge, you can use that pre-acquired information for those subsequent transactions. So the TSR establishes safeguards to protect consumers in telemarketing transactions in which there are pre-acquired account information that's obtained by the seller or telemarketer. So there's two instances when this is important. The first is when pre-acquired account information is used and the offer includes what's called a free-to-pay conversion feature. And this is more commonly known as a free trial offer, and which I touched upon a little bit before. Free trial offer, for example, would be you have 14 days to try this product for free, and maybe there's a shipping and handling charge, and maybe there's not. But you get the product for 14 days, and if you like the product, you don't have to do anything. You keep getting charged every 30 days thereafter until you call to cancel. That's also a negative option feature, which we talked about previously. So in this instance, there are going to be multiple transactions that occur on a monthly basis until the consumer calls to cancel. And for those transactions, you can use the credit card information that the consumer gave you initially for the free trial offer. But in order to do so, you have to follow a few rules. First, you have to obtain from the customer at least the last 4 digits of the account number to be charged. You have to inform the customer that you have the account number or the ability to charge the account without getting the full account number from the consumer. It's not sufficient to just read the digits to the customer or ask the customer to recite them back. You just have to make sure that you've given them the full information about the fact that they're going to be charged. You also have to obtain the consumer's express agreement to be charged for the goods or services and to be charged using the account number for which the customer has provided at least the last 4 digits. And then, of course, you have to make and maintain an audio recording of the entire telemarketing transaction as proof on demand later on that you were authorized to make these kind of charges on their account. And then we have the instance where the TSR establishes separate requirements for pre-acquired account information transactions where there is no free-to-pay conversion feature. In those instances, the telemarketer has to, at a minimum, identify the account to be charged with enough specificity for the customer to understand that the account will be charged, meaning you identify the card through the name of the issuing bank or some portion of the account number. And then again, of course, you need express agreement, which is affirmative and unambiguous statement from the consumer that demonstrates an intent to be charged on a specific account. So that's basically the TSR in a nutshell for call recordings. Again, the TSR has record-keeping requirements. It requires the sellers and telemarketers to maintain certain records for 2 years. And this is where call recordings come into play and are important. So, for instance, they have to keep advertising and promotional materials for 2 years. They have to keep information about prize recipients, sales records, employee records, and again, all verifiable authorizations or records of express informed consent or express agreement. So it could be a video or audio recording, or it could be something in hard copy, but they have to include all information that was disclosed to the consumer, as well as the consumer's oral authorization. Again, records can be maintained in any format or any manner, as long as they're kept in the ordinary course of business. So if your practice is to maintain call recordings, then that's how they should be kept. And sellers and telemarketers don't want to have a duplicative obligation to keep records. So let's say that the seller, meaning the advertiser, tells the telemarketer that they've contracted with that it's your responsibility to keep these records. It's enough if the telemarketer keeps the records. The seller also does not have to keep the records. And the vice versa is true, of course. Another instance where call recordings is important is under the Telephone Consumer Protection Act, the TCPA. And I'm sure many of you know about the TCPA, and it's a belabored topic that comes up in lots of webinars dealing with call recordings. So I won't spend too much time on them, on the rules, but I just want to go over some key rules that people seem to forget when it comes to the TCPA. So first, just a quick background, the TCPA has been around since 1991. It got a lot of attention in 2013 because there were certain rule changes that were made to the TCPA, which I'm going to discuss in a moment. When it first got started and when it was first passed, it was really in response to blast faxes, and that's, you know, when people were sending out messages via fax machine, which some of you may be familiar with. It's not a practice people keep to this day, but that's what it was really in response to, making sure the consumers were protected from unsolicited calls or messages relating to telemarketing. The key change that came in 2013 is that the prior express written consent is required in certain instances. And the first is when we look at mobile phones. The rule change is that marketers must receive prior express written consent from consumers before placing auto dial calls, text, or generating pre-recorded messages to cell phones for telemarketing purposes. So the question is, how is the message being sent? Is it via auto dialer or a pre-recorded message? And for what purpose is it being sent? Is it for a telemarketing, a sales purpose? Now, there are certain exceptions, as there are with any rule. The exceptions here are if you're making a live telemarketing call, not using an auto dialer, to a wireless number, you do not need to consent. Or if you're making a live informational call without an auto dialer to a wireless number, you also don't need consent. Now, the definition of auto dialer is pretty broad. The FCC has interpreted it very broadly as anything that has the capacity to store or record calls. It could be anything like a cell phone, technically could be an auto dialer. And there's been a lot of litigation and disputes around what an auto dialer entails, and that's going to continue to be litigated. But for anything, you know, a manual phone, a rotary phone, anything of that sort would not be considered an auto dialer. Now, with landlines, there are different protections because many people these days don't actually have landlines anymore. I know that the only people who ever called me on a landline are telemarketers. I use my mobile phone for everything. So the rule here is for landlines, marketers must obtain prior express written consent before generating pre-recorded telemarketing messages to consumers' landlines. Again, there are exceptions. The exception being live telemarketing calls, whether you're using an auto dialer or not, to residential lines generally do not require consent. Additionally, live informational calls, again, whether it's with an auto dialer or not, to residential lines do not require consent. What is consent when it comes to the TCPA? Like the TSR, consent needs to be unambiguous. It needs to be clear and conspicuous disclosure. Consent also cannot be a condition of purchase. You can't require someone to consent to being called by an auto dialer simply to get them to move forward with the purchase of that good or service. It also requires a consumer to designate a phone number. Is this a cell phone number, a landline? Sometimes that question is asked, but they need to put down a number at which they will be contacted. How do you obtain consent? Well, there's different ways. The eSign Act lets us do it via website form. So for instance, you'll see lead generation sites that will be aggregating leads for, let's say moving companies that may respond to your inquiry. When you submit your information, you submit your cell phone, you submit your name, you say, I consent to being called, and you opt in through an affirmatively opt in through a checkbox that's not pre-populated on the form that lets the telemarketer call you, that specific seller call you via auto dialer or pre-recorded message to that number. You can also obtain consent through email, through text message, and it's important to know that text messages are also covered under the TCPA. You can get it through telephone key press, and importantly for purposes of this webinar, you can get it through voice recording. Now there's some confusion as to how consent can be revoked, and this was clarified in the order that came out from the FCC in July of 2015, in which they said a consumer can revoke consent in any reasonable way at any time. So whether in writing or orally, they can do it in a way that's reasonable. The burden of proof of obtaining consent is always on the seller. Even if you have marketers who are calling on your behalf, you as a seller bear the burden of proof. And which is why it's so important to have call recordings, especially if you're capturing consent orally. Those call recordings must be maintained for at least 4 years, and they are the best proof of consent and a revocation of consent. And so with TCPA litigation, the best way to mitigate your exposure or to get out of a lawsuit is say, hey, this person signed in. Here's a call recording. Here's the language we gave them on the website form. I've had cases where plaintiffs' lawyers have brought TCPA lawsuits, and within 3 minutes of showing them our opt-in language and capturing that record of that language, they dismiss the lawsuit for no money at all. And the same would be the same for call recordings. If we had a call recording that you could give them and say, hey, here's where we gave disclosures, here's where they opted in affirmatively to getting called, that's going to be the best way to get out of a lawsuit. So certain do's and don'ts are obvious for the TCPA. I won't spend too much time on this in the interest of time, but obviously obtain prior express written consent prior to initiating or sending telemarketing calls, and make sure, or text messages, and make sure those any disclosures you make are clear and conspicuous. Try to provide one or more opt-out mechanisms. If you're sending text messages, always have reply, stop, or end to opt out of these messages. Maintain a do not call list, both internally and also scrub against the federal and state do not call lists. And honor any request not to be called again. Don't call people if they said, don't call me, because once you start calling someone who said, I don't want to be called anymore, that's considered a willful breach of the TCPA and could subject you to $1,500 in fines for each violation. Make sure you keep a clearly written policy that's available to anyone upon request as to your TCPA and retention policies. You make sure you train your personnel making the telephone solicitations, and of course keep records for at least 4 years. Some obvious don'ts are, don't assume that the consent received in the past remains valid. People change numbers, people opt out of things later on. If you have consent, sometimes it's only good for a limited period of time. Also, don't place unnecessary restrictions on the scope of consent. If they're consenting to be called for one thing, don't think that that applies to anything else you're trying to sell them. So if you're trying to find them movers, don't think that that also applies to you finding them, for instance, home warranty. Don't also assume that a device is not an auto dialer. It's, like I said before, the FCC has defined auto dialer very broadly as anything having the capacity to store or record numbers. And also don't assume that you're safe from TCPA liability because you're using a telemarketer or a third party to make calls on your behalf. As a seller, you always have liability. This brings us to our final topic for today's webinar, which is going to lead into Brett's discussion and some questions. What is PCI compliance? So PCI compliance and how it's relevant to call recordings comes into play because the payment card industry, which is what PCI stands for, has data security standards. That's what PCI DSS is, that have gained significant attention in the call center market. They are founded by American Express, Discover Financial Services, MasterCard, Worldwide, and Visa International have all founded something called the PCI Security Standards Council, whose mission it is to enhance payment account data security by fostering broad adoption of the PCI security standards. The council was created in 2006 to create a set of rules for merchants and service providers. And this council was followed by the data security standards, which detail security requirements for anyone processing, storing, or transmitting data. As we know, identity theft is pervasive in today's economy, and consumers need to be protected. And the PCI DSS takes great measures to help safeguard consumer account information and minimize or eliminate the potential for identity theft. So they apply to all merchants and organizations, as I said, that store or process or transmit this data, regardless of the size or number of transactions. Compliance with the PCI set of standards is mandatory for the respective stakeholders and is enforced by major payment card brands who establish the council. So non-compliance basically means that the service provider could be terminated for card acceptance privileges in the future. Now, there are certain exceptions. The PCI DSS requirements are only applicable if a PAN, which stands for primary account number, is stored, processed, or transmitted. Otherwise, the requirements do not apply. So there are certain best practices that should be adhered to when it comes to PCI compliance. The first is install and maintain firewall configuration to protect cardholder data. Don't use vendor-supplied defaults for system passwords or other security parameters. You're just opening yourself up to potential breaches by doing that. It's like when people use the word password as their password, you're just a sucker to get a data breach. I mean, it's like bending over and asking someone to pick your pocket. Employ antivirus software, anti-spyware programs, and other malware protection solutions. You want to encrypt transmission of cardholder data across open public networks. You also want to restrict physical access to cardholder data. Not everyone in your company needs to be able to access this information. Your agents may not need to be able to, maybe just supervisors and directors should. And again, you also should restrict the access to that data on a need-to-know basis. Who in the company needs to have access to it and who does not? You also want to implement strict authentication controls for all employees with access to call recordings. A lot of times we see in call centers people using whiteboards. That's always a better practice than having your agents or reps use pen and paper. We don't want to have anything that can be recreated even after it's torn up. Whiteboards can be erased, and there it goes, and there's no need to store that data. You also want to prohibit mobile phones in call centers. That's just asking for a data breach right then and there. You want to make sure you document and adhere to formal information security policies. You want to maintain systems to secure configuration standards and regularly test them for vulnerabilities. And of course, check and review the PCI DSS policies for call centers and implement them in agent training. And those are available online and through the card brands. And these are the practices they want you to comply with. And why is this also important? Before I turn it over to Brett, well, because in 2016, we had an all-time high for data breaches in the U.S. The Identity Theft Council reported a total of 1,093 security incidents that involved the loss of sensitive information that were disclosed in 2016, meaning those are the ones that we know of. There could have been a lot more that we don't know of because they weren't reported. This number represents a 40% increase over 2015 reporting. Now, what's important to note is that there are 47 states, plus DC, Guam, Puerto Rico, and Virgin Islands, that have legislation requiring private or governmental entities to notify individuals of security breaches of information involving personally identifiable information. So the different state laws address who has to comply, what constitutes PII, what constitutes a breach, when you have to, the timing of when you have to notify customers and what you have to put in your notices, and when certain exemptions would apply, like, for instance, encrypted information that was breached. You also have to report it to your individual state AGs in addition to reporting to your customers. And each state has different requirements. It can be very costly, and it can be reputationally harmful to some people to do it. But the effects of not doing it are even worse. If you had a breach and you don't disclose it later on, and you're investigated or someone else finds out you had this breach, the ramifications could be astronomical. We saw this a little with Yahoo, where they underreported their breach of data. And so what we see here is, even if you report, that's not the end of the line. You could still be subject to governmental investigations and private plaintiff lawsuits for the data breaches. And with this, I want to turn it to Brett before we get into questions to talk a little bit about the PCI redaction tool that Convirza has.
Yeah, thanks, Rachel. So recently, Convirza has put together a redaction tool that allows for call centers or anyone that is recording calls to have those call recordings redact the credit card information that is sensitive in these calls, right? So you can become what we would say is PCI compliant. And so what it allows you to do is to be compliant with the with PCI, along with maintaining your call recordings for your compliance for other issues and also for your training. So specifically, we're typically focused on those that are doing inbound calls and transaction off those calls. But we also have the ability to, if you're recording, doing outbound and have those recorded, you could send those to us, and then we could do redaction on those call recordings. So if you do have an interest in looking at those options that we have and getting more details on that and seeing a demo and pricing and all those type of things, you can hit me up in the question section there, or we're going to follow up with you via email. And if you have an interest there, you could always respond back to one of our agents. So yeah, we are excited about that because it's been something that is a big need for most of our customers that are doing transactions over the phone and need to be able to redact that information for PCI compliance. So we are excited about it. Rachel, we have a couple questions. I'll kind of slip in here before the bottom of the hour, and we have to wrap up, that I had. One question was, they're doing outbound calls in a one-party state, and so this question was, if the agent is placing the call, knows the call is being recorded, then we're okay. Is that accurate?
Well, if you're doing outbound calls if you're in a one-party state doing outbound calls to another one-party state and the agent knows, then you're okay. But if you're doing outbound calls in a one-party state to a two-party state, then it's probably better to disclose that the call is being recorded in that instance. So sometimes you may not know what state the person's in because that information wasn't transmitted to you. Like, let's say they signed up via the web form. Sometimes, they may not live there. They may have a phone number that's associated with that state, but that's not actually where they are. So it's always best policy to disclose that the call is being recorded.
Got it. And the other question we had here is, they said we're a nonprofit senior housing healthcare organization. Could you elaborate on the nonprofit compliance that you mentioned earlier?
Well, yeah, that's a very broad topic. So I'm going to say this. I'm happy to discuss that in more detail because you also have HIPAA disclosure requirements from a healthcare perspective that you have to be concerned with, which I didn't touch upon here just for the sake of time. But there are TSR requirements for nonprofits too, and I'm happy to address that in more detail because it's not a question that can be answered in a minute or two times. So please feel free to call me or email me after the webinar. I'm happy to address that.
Okay, appreciate it. The last question we had is, did you say all the companies selling advertising services are not controlled by TSR?
Can you repeat that question, Brett? I'm not sure I captured it.
Yeah, did you say that companies selling advertising services are not controlled by TSR?
Well, I'm going to go back to that slide. I don't think that's what I said, but I'm not sure what they mean by advertising services. Are we talking about like an affiliate marketer, or are we talking about someone who, like a media company? the person elaborate as to what they mean by advertising services?
I didn't get that from the slide either.
Yeah,
so
I'm not sure.
I would any service being sold via telemarketing, whether it's advertising service or not, would be under
subject
the
to TSR.
Yeah.
Yeah. But if there's something more to that question that maybe we're not understanding, feel free to, again, reach out. But I don't think that that's what we meant. If you're selling something, whether it's advertising, product, whatever it is, if you're in the process of sales and you're telemarketing that, then you're subject to TSR.
Okay. All right. I think that answers that question. If not, you guys can type in more. So I think that's all the questions. I appreciate everyone that has shown up, and like I said, we'll follow up with you. And if you have any other additional questions for Rachel, you've got her email and phone number right here that you can reach out to her specifically. And if not, we appreciate Rachel very much. That was great, and we'll look forward to seeing everyone. Hopefully you guys can come again on another webinar, and we'll talk with you soon. Thank you, everyone.
Thanks, everyone.
All right, bye.